Friday morning started like any other, but in the world of the Trumps, ordinary rarely lasts. At 6:47 a.m., U.S. Marshals arrived at Ivanka Trump's Miami residence. Court documents would later show that they came for more than just paperwork. They came for answers, accountability, and, according to the filings, to take control of a labyrinthine web of assets and transactions that had been quietly monitored for over 2 years. By the time they left, they had Ivanka's passport, $127 million tied up in a network of 23 shell companies, and a paper trail spanning multiple states, all anchored by one unexpected 2-hour testimony from someone no one fully anticipated, Melania Trump. If you were following the headlines, you saw the surface story. Passport seized, Ivanka under scrutiny, money involved. But reading through the filings, all 187 pages of them, a different story emerges, one that changes the entire narrative of how the federal investigation unfolded. These aren't just numbers or legal jargon, they're a window into the inner workings of the Trump family, their business dealings, and the legal strategies that have now intersected in unprecedented ways. Melania's testimony, behind closed doors, became the pivotal moment that transformed a paper investigation into a human story, showing just how intertwined family, business, and the law can become. Here's the context. Ivanka Trump, former senior advisor to the president and a prominent figure in the Trump Organization, manages multiple business entities across 6 states. The newly surfaced court records reveal alleged patterns of financial transactions that federal investigators interpret as potential money laundering orchestrated through a network of LLCs. The indictment doesn't pull punches, pointing to direct wire transfers, offshore entities, and structured withdrawals that appear to deliberately skirt federal reporting requirements. From March 2023 to November 2024 alone, the filings indicate Ivanka's signature authorized 31 separate wire transfers, totaling $84.7 million, sent to a mix of Cyprus holding companies, Cayman Island subsidiaries, and Nevada-based LLCs, with no employees, no revenue, and no physical office. The filings argue that these transactions represent more than poor bookkeeping. They suggest a systematic effort to obscure the flow of money. On page 47, in Exhibit F, the filings show something even more meticulous. Ivanka personally withdrew $3.2 million in cash over 14 months, never exceeding $9,500 in a single transaction. That number is deliberate. The federal reporting threshold for cash transactions is $10,000. Repeated withdrawals below this limit is what prosecutors call structuring, a potential indicator of intent to evade federal reporting requirements. The filing notes that Ivanka, having served in the administration, had specialized knowledge of these laws. This wasn't an accidental oversight. According to federal prosecutors, this was calculated, precise, and documented. But the real game-changer came when Melania Trump entered the picture. She walked into a federal building in Washington voluntarily and sat down for a 2-hour testimony about her stepdaughter. No immunity deals have been publicly disclosed. She wasn't compelled. She wasn't subpoenaed. And yet, within hours, U.S. Marshals were at Ivanka's Star Island residence in Miami, executing a court order. Passport surrendered. Bond set at $15 million. GPS monitoring implemented. Devices scheduled for surrender. The legal machinery moved faster than anyone expected, and the documents make it clear this was not improvisation. Prosecutors had a plan, and Melania's testimony fit into it perfectly. The filings indicate that the investigation began with the Trump Organization but quickly expanded, uncovering something within the family structure that prosecutors found compelling. Patterns of money movement through shell companies, wire transfers across states and countries, and withdrawals just below the reporting threshold created a mosaic of potential wrongdoing. But documents alone aren't enough in these cases. Context matters. That's where Melania's testimony comes in. According to the filings, she witnessed conversations in which Ivanka allegedly instructed associates to keep transactions below the $10,000 reporting threshold. Keep it under 10. Always under 10, she reportedly said. In the eyes of prosecutors, this direct witness testimony, combined with the financial evidence, created a clear picture of deliberate action. The defense has pushed back. Ivanka's legal team argues that these offshore entities had legitimate purposes, licensing deals, brand management, and international contracts that required the movement of funds across borders. They point to 47 pages of business records and contracts showing the rationale behind each transaction. Regarding the structuring allegations, the defense stresses that withdrawing amounts under $10,000 isn't inherently illegal. Intent must be proven, they argue, and patterns alone cannot establish criminality. Critics also note that family dynamics, Melania's incentives, and political timing could color her testimony. The debate isn't simple. On one side, prosecutors see patterns and direct statements. On the other, the defense presents plausible business explanations and questions of motive and intent. Both sides are armed, but certainty is elusive. The court's decision to seize Ivanka's passport, order GPS monitoring, and require surrender of all devices used for business communications since 2021 signals the seriousness of the federal response. Devices including laptops, phones, and cloud storage must be turned over by February 11th. Forensic experts will examine every message, every deleted communication, every encrypted file, seeking corroboration with Melania's testimony. If the communications align with her statements, the prosecution strengthens. If not, the defense gains leverage. The upcoming device compliance deadline is a critical juncture. It could either solidify the case or expose weaknesses. This case isn't just about one family or one former White House advisor. It has implications for how prosecutors approach high-profile financial crimes involving family networks, offshore accounts, and structured withdrawals. Small business owners, investors, and anyone handling significant cash transactions should take notice. If you've ever split a large purchase into multiple transactions to stay under reporting thresholds, federal eyes are watching. The precedent being set is significant. Convictions here could embolden aggressive enforcement nationwide. Failures could offer defense blueprints for future challenges. The legal landscape is shifting in real time. Beyond the law, the market impact has already been felt. Shares in Trump-affiliated businesses dropped sharply following Friday's developments. Bonds fell, and investors are recalculating exposure to politically sensitive assets. The financial contagion is tangible, and the ramifications extend beyond Miami or Manhattan. We're watching a case that bridges the private and public, the personal and political, and the domestic and international. The sequence of events is also a study in strategy. Melania's voluntary testimony changed the case from abstract numbers into human drama. The timing of the passport seizure, bond setting, and device orders show prosecutors orchestrating their approach meticulously. The Trump family's complex web of business dealings, previously shielded by privacy and corporate opacity, is now under federal scrutiny, piece by piece, email by email, transaction by transaction. And in the background, the defense is pushing back, filing motions to modify travel restrictions, gag orders, and device surrender timelines, all while maintaining the argument that the investigation is politically motivated. Experts weigh in, and the analysis is mixed. Former federal prosecutors point out that passport seizures and GPS monitoring are strong indicators of perceived flight risk and prosecutorial confidence. Family testimony is rare, powerful, and compelling, especially when voluntarily given. Yet criminal defense attorneys caution that intent is difficult to prove, and structuring charges often hinge on subtle nuances of knowledge and purpose. Constitutional scholars highlight precedent and fairness, noting that stepchildren are not protected under spousal privilege, so Melania's cooperation is legally valid but socially fraught. The tension between legal strategy, family dynamics, and public perception is unprecedented. Looking forward, several key dates are pivotal. The device compliance deadline of February 11th, the status conference, and subsequent grand jury sessions could bring new charges or clarify the prosecution's strategy. Every filing, every ruling, every testimony contributes to shaping both the immediate case and broader legal precedent. The documents, so meticulously compiled, show a case moving faster than many high-profile investigations, signaling both urgency and confidence on the part of federal authorities. At its core, this is about accountability, patterns, and precedent. The combination of structured withdrawals, shell companies, wire transfers, and direct witness testimony forms a complex but compelling narrative. Whether it culminates in a conviction or falters under scrutiny, the process itself is rewriting how similar cases will be approached in the future. The implications are real. Financial markets, corporate governance, family business operations, and the legal system are all being influenced simultaneously. Ivanka Trump's case has become a lens through which the broader interplay of law, politics, and family can be examined in granular detail. The next steps will be decisive. How Ivanka's legal team responds to device scrutiny, how the court rules on pending motions, and whether any new evidence emerges from grand jury proceedings will dictate the trajectory of this investigation. In parallel, public perception is being shaped by a carefully calibrated release of information, selective media coverage, and official statements. Melania's role, while central, also highlights the tension inherent in family cooperation with federal investigations. Her testimony underscores both the legal leverage and the ethical questions that arise when personal relationships intersect with public accountability. This case is not over. Far from it. It is evolving at a pace rarely seen, involving multiple jurisdictions, layers of financial complexity, and family dynamics that make conventional prosecution challenging. But the filings make one thing clear. Federal prosecutors are taking an unprecedented approach, combining documentation, witness testimony, and proactive enforcement measures to build a case that is both robust and strategically timed. What happens over the next few weeks, compliance deadlines, status conferences, grand jury meetings will determine the direction of this high-stakes legal drama. So, as we watch, the key takeaways are, this is about far more than a single transaction or a passport. It's about patterns of behavior, legal accountability, family cooperation, and market consequences. Ivanka Trump's situation represents a convergence of legal scrutiny, political optics, and financial transparency that is shaping the future of enforcement in complex financial networks. For businesses, family offices, and individuals involved in cash-intensive or multi-jurisdictional operations, the lessons here are immediate and unavoidable. The stakes are enormous, the strategies are aggressive, and the precedent is unfolding in real time. This is the story of how one morning, 2 hours of testimony, and meticulous federal investigation collided to create a case that touches on finance, law, family, and politics simultaneously. It's a case that will be analyzed for years, not just for the outcome, but for how the process reshapes expectations around compliance, testimony, and prosecutorial strategy in high-profile financial investigations. Ivanka Trump's passport seizure is just the beginning. What follows will define a new era of scrutiny for family-run enterprises with national and international implications. By now, you should understand why Friday wasn't just another day in the Trump saga. It was a turning point, a convergence of law, family, and finance that has consequences far beyond Miami or the Trump organization. The passport seizure, the $15 million bond, the GPS monitoring, and the device surrender order aren't isolated actions, they form a coordinated strategy that signals prosecutorial confidence and seriousness. Federal authorities weren't improvising. They were executing a calculated plan. And Melania's testimony was the keystone. Every step since her 2-hour session underscores how carefully orchestrated this is, how quickly the legal machinery can move when evidence, witnesses, and strategy align. The devices themselves may hold the ultimate key. Laptops, phones, cloud storage, everything from business communications to encrypted chats will be analyzed. Investigators will compare these communications with Melania's statements. If the evidence corroborates her testimony, the case strengthens exponentially. If it contradicts her account, the defense gains critical leverage. These 4 days leading up to the device compliance deadline will be pivotal. In legal terms, this is where the abstract pattern becomes tangible proof, or where the prosecution risks overreach. Either way, the stakes couldn't be higher. This case also shines a light on the unprecedented role of family testimony in high-profile investigations. Spouses are protected under privilege laws, but stepchildren, adult children, and extended family members are fair game. Melania's voluntary participation gives prosecutors an unusually powerful witness, someone who can provide context, motive, and insight into otherwise opaque transactions. That's why her testimony matters far beyond the words spoken. It shapes the narrative, frames the evidence, and amplifies the weight of financial records. The legal leverage from family cooperation is a game changer, and Ivanka's team knows it. Meanwhile, financial markets are reacting in real time. Stock prices in Trump-affiliated businesses plunged, bonds fell, and investor sentiment has shifted sharply. The ripple effects are tangible. Any business with exposure to politically sensitive entities, cash, heavy operations, or international licensing agreements is recalculating risk. Portfolio managers, accountants, and legal advisors are reviewing transactions, ensuring documentation is airtight and preparing for potential scrutiny. This case has become a living blueprint of how federal enforcement can intersect with global business, family networks, and high-profile legal targets. Looking ahead, the timeline is critical. February 11th marks the device compliance deadline. Status conferences, grand jury sessions, and potential additional charges will follow. Every filing, ruling, and testimony will contribute to shaping both the trajectory of the case and broader precedent. If the devices confirm Melania's testimony, the prosecution solidifies its narrative. If gaps or contradictions emerge, the defense gains leverage to argue for dismissal or reduction of charges. The next 2 weeks are essentially the fulcrum on which this entire case pivots. Legal experts are watching closely, weighing evidence against intent, family dynamics against procedural fairness, and precedent against strategy. Former prosecutors emphasize that the passport seizure signals a serious concern about flight risk, reinforcing the weight of the case. Criminal defense attorneys caution that structuring cases are complex and hinge on proving intent, not just patterns. Constitutional scholars point to precedent, noting that political pressure and public scrutiny complicate high-profile cases. The consensus is clear. This is a rare combination of evidence, witness cooperation, and procedural urgency that doesn't come together often. And when it does, the stakes are enormous. For Ivanka Trump, this is more than a legal battle. It's a full-scale strategic challenge. Every decision her team makes, whether it's filing motions, negotiating device access, or presenting evidence, will influence not just her case, but how federal investigations approach family-run businesses in the future. Prosecutors are setting a precedent. They are demonstrating how to leverage documentation, witness testimony, and real-time enforcement to construct a case that is robust, rapid, and strategically timed. The lessons for corporate entities, financial officers, and high-profile families are immediate. Transparency, compliance, and preparation matter more than ever. The broader implications are even more striking. This case is reshaping expectations around financial accountability, family testimony, and corporate governance. It shows how patterns of money, movement, structured withdrawals, and shell companies can trigger serious federal scrutiny. It illustrates how witness cooperation, even from within a family, can amplify evidence and accelerate legal proceedings. It highlights the intersection of law, politics, and media influence in shaping both perception and reality. In short, this isn't just Ivanka Trump's story, it's a case study in how the modern legal system interacts with high-profile, multi-jurisdictional financial networks. We also cannot overlook the human element. Melania's voluntary testimony demonstrates how personal decisions intersect with law enforcement strategy. Ivanka's response, through legal filings and public statements, shows how family members navigate defense while under unprecedented scrutiny. The interplay between personal loyalty, professional responsibility, and legal obligation creates tension that few cases have ever captured in such granular detail. Every action, every motion, every communication carries weight because the players are high profile and the stakes enormous. As of now, the story is far from over. Device submissions, grand jury proceedings, and judicial decisions in the coming days will determine the next chapter. Legal analysts, market watchers, and the public are all focused on how the situation will unfold. Will evidence strengthen the prosecution's case, Or will the defense successfully challenge intent and motive? Will additional charges emerge, or will motions delay or mitigate proceedings? These questions remain open, but the trajectory is clear. This is a high-stakes, precedent-setting case that will influence not just the Trump family, but federal financial enforcement for years to come. In conclusion, Friday, February 6th, was a landmark moment. Ivanka Trump's passport, seizure, bond, GPS monitoring, and device surrender order were not routine. They were strategic, coordinated, and indicative of a high level of prosecutorial confidence. Melania's testimony provided the human context necessary to give the evidence depth and meaning. The interplay of financial transactions, legal strategy, family cooperation, and political implications make this case one of the most complex, fast-moving, and precedent-setting in recent U.S. history. Every move in the coming days, from device compliance to grand jury hearings, will reveal more about the strength of the evidence, the credibility of witnesses, and the effectiveness of defense strategies. This isn't just a legal story. It's a blueprint for how high-profile financial investigations may proceed in the future. For investors, small business owners, legal professionals, and observers of American politics, the lessons are immediate and profound. Ivanka Trump's situation is evolving at an extraordinary pace. The combination of strategic enforcement, unprecedented family testimony, and high-profile financial scrutiny is reshaping expectations and setting new legal and procedural benchmarks. How this case resolves will influence not only the Trump family, but future approaches to complex financial investigations involving family networks, offshore entities, and structured transactions. As the situation develops, the eyes of the nation and indeed the world remain fixed on Miami, New York, and Washington, watching how this unprecedented case unfolds in real time. Friday may have been just the beginning, but the consequences are unfolding, and they will be felt across courts, markets, and families for years to come. This isn't just a headline, it's history in motion.